Welcome to another episode of Special Needs Jungle in Conversation series with me, Renata.
And me, Tania Tirraoro.
Today, we have the pleasure of welcoming back Steve Broach, who many of you know as a long-term friend and an occasional contributor to Special Needs Jungle. Steve is a barrister specialising in public law, and he has a special interest in disability and children's rights cases.
Now, as you may have been hearing, the SEND improvement plan has now been published, and we are delighted to say that we'll be holding a round table on this next week with SEND experts, including Steve. But what you need to know now is what has changed, Steve?
Thanks very much for having me. First of all, delighted to be part of what Special Needs Jungle is doing again, and more power to your collective elbows. In terms of the improvement plan, when I got to the bit that said the law isn't changing, I have to say I decided much of it wasn't for me because I'm a lawyer. And it is clear that the government has taken the view that at this stage, there won't be any legal change. Now, that means that there isn't going to be draft legislation. There won't be a bill introduced to Parliament at this point. So the short answer to your question, Tania, is nothing has changed in terms of the law. And I think that the charities and other groups have done a really good job of getting that message out to parents that the improvement plan is essentially a policy plan which has lots of aspects to it, various funding announcements and so on, but which doesn't, of course, affect the law, because we all know that law trumps policy. So nothing changes immediately as a result of the improvement plan in terms of the SEND legal framework, and indeed the improvement plan doesn't promise any imminent changes in law either.
So luckily we're not doing our podcast on the improvement plan because it would be a very short podcast.
Yeah.
Okay, so moving on to the parent questions. Many parents are frustrated because there seems to be no way currently to really hold LAs to account quickly. So a child doesn't miss lots of provision. What can parents do? As many quote the CFA and the SEND code of practice, but this, as parents says, gets you nowhere.
Well, my experience is that understanding the law and being able to quote bits of relevant law does often get you somewhere. It can well influence and change behaviour and practice, in my experience, from time to time. Not always, of course. So when you've got to the stage where you've tried asking nicely, and you've tried asking the SENCO and the heads and the relevant governors, and you feel that there's no progress being made, there are usually a number of options open to you in terms of remedies, but none of them are perfect, unsurprisingly. So what are the options? Well, the first thing people think about usually in relation to SEND and legal remedies is the tribunal. The problem with the tribunal, of course, in terms of its SEN jurisdiction, is that it's limited to considering very specific appeals, types of appeal. So specific decisions that can be challenged in the tribunal, whether that be a refusal to assess, to carry out an EHC needs assessment, a refusal to issue an EHC plan, the contents of that plan, a decision to cease to maintain the plan, and so on. And you know if you can go to the tribunal because you get a decision letter that tells you you can go to the tribunal. And the tribunal won't allow you to register an appeal without that decision letter. So yes, the tribunal is a very important part of the remedies toolkit, but it's only available for a very small number of decisions. And one of the things the tribunal doesn't do, of course, is monitor the implementation of EHC plans. And so there are cases where families get a very good plan in terms of the words out of a tribunal appeal, where Section B identifies all the child's needs, Section F has all the provision that's necessary to meet those needs, but then it doesn't happen. And so what do you do in that situation, because the tribunal's job is finished? Essentially there you've got two options. There's the complaints process, which goes through the various local authority stages and then goes on to the local government ombudsman, or there's judicial review. Now, complaints processes are designed to be effective in terms of accessible to people. They're designed to avoid the need to incur legal costs, because you won't need a lawyer to advise you on your complaint. The other side isn't entitled to claim costs against you if your complaint is dismissed. The problem with complaints processes is, first of all, of course, the internal stages are internal within the local authority. And then in terms of the approach of the ombudsman, so the Court of Appeal has just decided an appeal in a case that I'm instructed in brought by a young man called Philip Milburn. And the issue in Milburn was, how much should the Ombudsman look at in terms of issues where the tribunal might have a say? And the answer the Court of Appeal has given is that where there are issues which the tribunal can or may resolve, then the Ombudsman shouldn't look at them, because the tribunal has jurisdiction. So that will, I think, narrow the number of issues that the Ombudsman will be willing and will say it's able to look at in this area, and maybe another barrier to families getting remedies where things are going wrong. Generally speaking, the complaints process, I feel, is the appropriate remedy where you've got historic issues and where you're looking for compensation, or where you've got issues that are of some importance but not overwhelmingly important. But where complaints processes don't usually work, in my experience, if you've got serious and urgent problems, things that are going wrong now. So, for example, a child is out of school, not getting any education. That's not suitable to be resolved by a complaint. That, in my view, is something that ought to be taken forward by way of judicial review. And judicial review is the process where the High Court reviews the lawfulness of decisions or actions by public bodies, or inactions, of course. And so the High Court judge isn't looking at whether it's the right decision. They're looking at whether it's a lawful decision, whether it's been made following an appropriate process, whether it's a reasonable decision, whether rational reasons have been given, and so on. The challenge with judicial review is you need a specialist lawyer to help you. I would never suggest that a parent embarked on a judicial review on their own. And in fact, that would be true even of those parents who happen to be lawyers themselves, because it's too much to expect a parent to bring a judicial review like that on their own. Also, of course, in the High Court, you can be expected to pay the other side's costs if you lose. And the cost might be tens of thousands of pounds. So normally, judicial reviews in our area are brought through funding via legal aid. Legal aid can be obtained for children and young people themselves, but there are complex rules around eligibility for legal aid, and in some cases it will be the parents' means that have to be assessed. So on my blog there's a list of specialist lawyers, specialist solicitors who have legal aid contracts. Not all of them, but a good number of them are on there, and those are people that families can try and can seek advice from. But if you're not eligible for legal aid, then you're left having to pay privately, at least for advice. And there are charities like IPSI and SOS SEN that will provide support, but their capacity, of course, is very limited as well. So it's not a happy picture, really, in terms of accountability and redress for families. It's quite a complex picture because you've got this interplay between the tribunal, the Ombudsman, and the High Court. And in order to go in the right direction, you probably need specialist advice right from the beginning. And then the question arises, well, how are you going to pay for that? I do think there's a big issue as well in our area about the fact that anyone can say they're a SEND advocate and put themselves forward as someone who can advise families, who can represent them in the tribunal and so on. In the immigration tribunal, which is part of the first tier tribunal, same as SEND, you can't do that. You have to have a certain qualification in order to be an immigration tribunal representative. In our tribunal, it's free for all. Anyone can do it. And I do worry sometimes that people are paying lots of money for not necessarily very high quality advice and support. Of course, one benchmark is whether the person's a lawyer, but shocking as it might be, just being a lawyer doesn't necessarily make you brilliant. Equally, there are some very good lay representatives that I'm aware of too. But it's quite difficult for parents to sort the wheat from the chaff, I think. And perhaps the best guide to who's going to do a good job is other people's experiences and past experience. Making sure that you are getting advice from someone reputable, I think, is absolutely critical, because if you go off on the wrong direction, if you launch a tribunal appeal when you've not got an appealable decision, or if you make a complaint on the basis that you have to bring a complaint before judicial review, which is absolutely wrong, then you're in big trouble, because these remedies, including particularly judicial review, they all have very tight time limits.
In fact, one parent asked the question, is it ever worth going down the complaints process, or just abandon it and go for court action and judicial review?
So judicial review is the remedy of last resort. And the courts are very clear about that. And in order to get a hearing of your judicial review, you have to get permission to apply. And one of the reasons why the court might refuse permission is on the basis that there was an appropriate alternative remedy. And quite often, public bodies will argue that a complaints process was available and should have been used as the way to avoid the need for the High Court to get involved. The test for whether a remedy is an alternative remedy should be used is whether it's convenient and effective. And that's something that the great Lord Bingham said in a case called Kay and Lambeth. And so that's always the question, is why can't you just make a complaint? And the answer to that would often be because it's so serious and urgent. And so you need interim relief from the court to sort things out while we have a hearing. Or there's an issue of law, because it's well understood that complaints processes are not suitable to resolve legal disputes. That's the job of judges. So if there's an argument about whether or not the law requires something to be done, that's a very good reason to go down the judicial review route. The short answer is you've got to get advice to know whether in your particular case the remedy is judicial review or a complaint. There is no hard and fast rule here at all. And getting that decision wrong is really bad news. And so that really emphasizes how important it is to get specialist advice at the beginning.
Okay, moving on to another question. Guidance on attendance for those with mental health difficulties has been amended. Legally, what rights do parents have when their child cannot attend school, and what can schools legally ask of you?
So if a child is unwell, they shouldn't be attending school. That's obvious. There's no legal requirement for a child who is unwell, who is too unwell to attend school, to attend school. The challenge, of course, in relation particularly to mental health is there may be a dispute about the nature or the extent of the child's ill health. And so, as with any kind of dispute, evidence is going to be really important. And so parents will need to have evidence from a relevant practitioner and professional to establish what it is that's preventing the child from attending school. Where parents want the child not to attend school, and there's a health-related reason for that, there is, of course, the duty under Section 19 of the Education Act 1996 that the local authority must ensure that every child of compulsory school age is getting suitable education at all times, taking into account their health needs, their special educational needs. And so the local authority may well, in those cases, have to provide tuition or some other form of educational provision if the child's not well enough to attend school. But it is reasonable to expect that the goal will be for the child to be able to attend school again, unless there's a specific indication in their particular case that that's not what's right for them. So as usual, and this does, of course, make things almost worse for parents. I'm here, first of all, saying, oh, you must get legal advice. It's very important that you get legal advice. But I'm also going to say, the lawyers can't do anything without evidence. And where parents have said to me in the past, I can only afford to have a EP assess my child or instruct a lawyer to help me in the tribunal, which should I do? Almost always the answer to that will be get the EP report, because you can work out and you can get advice and support on how to represent yourself in the tribunal potentially, but lawyers can't do anything without evidence. So the answer to the question is essentially, what does the evidence say about the child's needs? And then everything else will flow from there, should flow from there.
Because a parent did ask about, is it possible to get real flexibility on attendance written into an EHCP for a child who wants to stay mainstream, for example, but can't cope with attending every single day? Can they get it so it's a lower percentage is acceptable to allow recovery and so on, without coming into conflict with the LA? And obviously the government has a big push on getting 100% attendance. Very
much so, is the short answer. I regularly see Section F of EHC plans that specifies a particular pattern of attendance that's different to the usual 9 o'clock to 3 o'clock or whatever it might be in the local schools. Also bear in mind that the schools, of course, owe duties under the Equality Act, including to make reasonable adjustments for their disabled pupils. And the pattern of attendance, the school timetable, is a PCP, a provision, criterion, or practice, as the Equality Act refers to it, which the school would have to make adjustments to the extent that it's reasonable to do so. And reasonableness requires balancing all the circumstances. So yes, there might be a degree of disruption to the school if the child is attending at a slightly different pattern of time, or is having the odd morning off, or whatever it might be. But that's got to be balanced against the benefit to the child of allowing that. And also the right to mainstream education, which I think can be lost sight of in the discussions sometimes. There is a fundamental human right for disabled children to be in mainstream schools. It's in Article 24 of the UN Convention on the Rights of Persons with Disabilities. And that right to mainstream education is reflected in the Children and Families Act, sections 33 to 35, put a very high priority on children with SEN and disabilities being in mainstream schools. And there's a very important section, I think, section 35, that's sometimes forgotten about, which talks about meaningful inclusion. It talks about children being educated with their mainstream peers. So not just placed in a unit on the same site as a mainstream school, but actually being in the mainstream school in a meaningful way. So all of that, I think, goes to the point that adjustments like being allowed to attend at different times or at different patterns is generally going to be reasonable.
But presumably, so, if it's Equality Act, you don't even need an EHCP plan to...
Absolutely, Tania, and I think that's a really important point for parents to understand. The golden ticket narrative is obviously horrible, and SNJ has rightly called it out. It's particularly horrible, I think, because it ignores the extent of the duties on schools for children who don't have EHC plans. There are very important obligations on schools for all disabled children and all children with special educational needs. So section 66 of the Children and Families Act that tells the governors they have to use their best endeavours to secure all the special educational provision that every child in the school needs, regardless of whether they've got an EHC plan. But yes, absolutely, the Equality Act duties all apply to every disabled child in the school. Nothing to do with whether you've got an EHC plan or not. In fact, actually, the EHC plan might somewhat reduce the Equality Act duties, because it would be said, well, the school has less to do because the local authority ought to be doing more under the EHC plan. In terms of what's reasonable for the school to do, if provisions in the EHC plan, it would be said, well, it's for the local authority to secure that. They've got a specific duty to make that happen. So the school perhaps needs to do less. So ironically, parents could find that by getting the golden ticket, as it's unacceptably described, of an EHC plan, they've reduced the obligations on the school. The point is this: children who need EHC plans should have them. And the law is very, very clear about what that means. You might want to ask me about that in a minute. The cohort, the much larger cohort of children who don't have EHC plans, many of whom shouldn't have one because they won't meet the legal test, are still protected in very significant ways by law. And one of the points we haven't yet talked about in terms of remedies is the disability discrimination jurisdiction of the tribunal. And the tribunal, as you think about it, is quite a strange beast, because it has this extensive SEN jurisdiction in relation to local authorities, but it doesn't have any SEN jurisdiction over schools. And then it has a disability discrimination jurisdiction over schools, but not over local authorities. If you think the local authorities discriminated against you, your remedy is in the county court. So they're really two very separate jobs that the tribunal does, which are joined together in this idea of SENDist. And the disability discrimination jurisdiction in relation to schools is available to any parent of any disabled child.
I mean, do go on with what you were going to. You wanted us to ask you, please. So
when should a child get an EHC plan? So the law on this really is quite clear, and what I always find interesting, shall we say, is local authority policies in relation to certain numbers of cycles of intervention or what have you. Have all got nothing to do with the very straightforward statutory test, which is that the child has special educational needs, well, obviously, and that it's necessary for special educational provision to be made for them in accordance with an EHC plan. And the law doesn't identify or delineate when it might be necessary. So there could be any reason why it might be necessary, but generally it will be either because the child's going to attend a special school, because we know that almost all children who attend special schools will have EHC plans, and that's a requirement, or because the provision in Section F is more expensive than the mainstream school can reasonably be expected to fund from its own resources, which is the ballpark figure that we all know of £6,000 a year. And so when you think about that, well, what does £6,000 buy you these days?
And it hasn't been increased since before 2011, 2009 even.
Exactly. The answer is not that much. And so where you've got children with any significant level of provision in Section F, they are likely to go into Section F of the EHC plan, because of course at the point the local authority makes that decision, we don't know what the plan is going to say because they haven't written it yet. Then they need to have an EHC plan. So the threshold is high, but not that high. You know, we're talking about children and young people with significant levels of special educational needs. Bear in mind, of course, that you can have the most complex health or care needs and not come anywhere near the threshold for an EHC plan, because the whole focus of that legal test is on your educational needs and provision to meet your educational needs. And that, one might think, is something that could usefully be looked at in terms of a joined up statutory system. Why is it necessary to prioritise education in that way?
Although you could say that people with significant health needs, that will have an impact on the education anyway. And actually what happens is it's marginalised into the health section and they don't consider how health impacts on education.
Very much so, Renata. And bear in mind, of course, the Section 21, subsection 5 of the Children and Families Act, perhaps the most controversial subsection of that legislation from our perspective, which says that provision which educates or trains the child or young person becomes educational provision, even if it would normally be seen as health or social care. So local authorities are still getting that wrong. Parents don't understand that very often as well, which means that, for example, almost all therapy provision, because it educates or trains, should be in Section F of the EHC plan and becomes the local authority's responsibility to secure. So there's almost a positive flip side of this education focus of the whole scheme, which is lots of things become education that might not normally be thought of in that way. I wonder if we might have a rather more straightforward system that just says we identify children's needs and then we meet them wherever that they may happen, whatever bit of the legal jungle they may happen to arise from. But that's not how the Children and Families Act works.
Unfortunately.
Well, there are all sorts of legal issues that I think it would be fantastic if the government would consider in terms of potential changes. Unfortunately, apart from potentially in relation to social care, where the Law Commission is going to have a look at what is frankly a mess at the moment, the legal issues they're thinking about changing and which are mentioned in the improvement plan aren't the right ones from my point of view.
So talking about the improvement plan, which we're not going to really discuss, but there have been inquiries and reports and court cases before the plan came out, but nothing seems to work. And this plan aside, what would you do if you were in government to force broader permanent correction?
I'd increase the funding by an exponential amount. I think that the reality is that most local authority send officers don't want to make bad/unlawful decisions. The erosion of local government finance over the last, whatever it must be, 15 years now, is the root cause of most of the problems. We have a system which requires local authorities to fund whatever it costs to meet children's needs. And that's what the tribunal does, quite rightly. It does its job. It looks at the evidence and says, well, this child needs this placement. And the fact that that placement costs £80,000 a year, well, that's nothing to the point, because that's what they need. But local authorities have fixed budgets and they have to set their budget every year. And they're only allowed to increase council tax by 4.99% without a referendum. So how is that circle supposed to be squared? And so this isn't a legal issue, because I think, broadly speaking, there are lots of things that I'd like to improve about the Children and Families Act, but it is, broadly speaking, fine. I think that's the general consensus in the sector, isn't it? Is that there's nothing fundamentally wrong with the statutory framework. What's fundamentally wrong is that people don't follow the law. And how do we make that happen? Well, we could increase the powers of watchdogs and regulators, or we could just give local authorities enough money to actually do their job properly. And I'd much rather do the second of those things. Saying that, local authorities do continue to have choices. One of the things I'm always interested in is the frequency at which bins are being collected by local authorities. You might notice, particularly if you live in a more affluent area, the bins are still collected very, very regularly. That's because if local authorities don't ensure the bins are collected regularly, they get voted out. And when you think about those sorts of choices, political priorities locally, it does paint a slightly different picture in terms of how bad SEND services are in some areas.
Self-interested.
Well, local authorities are in an extremely difficult position, but they are still making extremely difficult choices. And the question is, are they going to prioritise this area?
We know that there's currently a 1-year wait for tribunal hearings, and which isn't good, obviously, in itself, but hearings are supposed to be expedited for the phased transition. Yes. But parents are telling us that this doesn't appear to be applied consistently. So what can parents in this position do? I
think this is a really massive problem, because the tribunal is breaking down as an effective remedy at the moment. It can't possibly be acceptable for any tribunal appeal to take a year to resolve. I mean, EHC plans are reviewed once a year. Where you've got something as urgent as phased transfer or children who are out of school, the tribunal says that it's prioritising those appeals, but my experience is that it's not. The only way the tribunal will prioritise those appeals is when the parents get the registration letter. They then need to file a request for changes, having spoken to the local authority first, and say, can you bring this forward? And when they file that request for changes, it goes before a judge, and the judge will normally bring the hearing forward. But parents don't know that unless they've got specialist advice, and that's massively unfair. So yes, the message that needs to go out to parents is you shouldn't just accept that if you issue an appeal now for a child who is being seriously prejudiced by the dispute, it won't get listed until March 2024. That's completely unacceptable. You will need to file the request for changes form, which really, again, is this sort of fiction of accessibility, because it should be called an application notice. That's what it actually is. It's a way of applying to the tribunal to make something different in your case than it is at present. But the tribunal requires, before it will consider the application notice, that you've consulted the local authority first. And so parents will need to give the local authority a reasonable period, a couple of days perhaps, to comment on whether or not the hearing date should be brought forward. But I'm definitely aware of parents who have specifically said in the cover email and in the text of their notice of appeal, this is urgent, this needs to be listed as a priority, and that's just been ignored. It's not that the tribunal has considered that and dismissed it. They, as far as you could tell from the paperwork, it's just been ignored, and they've been listed in the ordinary queue. So yeah, 11, 12 months on from the date of issue. So it's really troubling, because again, it puts the burden on parents, and it creates an unfairness where those parents who know this, or who've got a lawyer who knows this, can do something about it, and those who don't sit and wait.
So parents can then go back and flag it up again and say, look, did you miss this? Did it?
Yeah, even more than that, I would just simply put in a request for changes form that says, you've listed this hearing in March 2024. We said in the application that this is urgent. That can't possibly be good enough. Please bring this hearing forward to, for example, June to July 2023. And the local authority's views on this is X. And so you need to tell them what the local authority says about things. And most local authorities, in my experience, have said, we agree. But again, it's the hoops, isn't it? Can you jump through the hoops?
And another big issue that we hear a lot about is transport. But transport to an alternative provision for a child who doesn't attend school, even if registered there. Now, some LAs will provide transport to the AP, but others will blankly refuse. So what does the law say about transportation to AP if the child's been sort of excluded from their actual original school?
Yes. So the law on school transport is a bit of a mess. And I think the best answer I can give to that is definitely an issue that you're going to need specialist advice on. Don't just accept that you're being told that we're not providing the transport. The ratio of unlawful decision-making in transport is even higher than in other areas of SEND, in my experience. So definitely don't just believe what you're told or accept what you're told, but get advice about whether that particular decision is challengeable, because it will be quite fact sensitive and will depend, for example, on whether the child is attending the alternative provision 5 days a week, or if they're going to the named school at all, the duration of the AP placement, and so on.
Children, obviously, quite a few children that go to alternative provisions don't have EHC plans. So what are their rights when it comes to transport, or other children who perhaps are attending specialist provision further away from home, but their children don't have an EHC plan?
The school transport entitlements have very little to do with EHC plans. And that's, again, another area that people are understandably confused about, because you might think that one of the things that an EHC plan would deal with is how you're going to get to school, and it doesn't at all. That's not part of the EHC plan. The only relevance of an EHC plan is that if it names a school in section I, then that will be assumed to be the nearest suitable school for transport purposes, unless there's been an agreement by the local authority to name the school, even though it's not, in their view, the nearest suitable school. And some local authorities will offer that on the basis that the parents will then have to arrange their own transport. Again, you can not accept that arrangement. You can say, no, I want to go to the tribunal and establish that this is in fact the nearest suitable school, because then you'll have to provide the transport. Parents don't always know that they can do that either. But generally speaking, the entitlements to transport are triggered by distance from between the home and the school, and unsuitability or inability to walk if you're within the statutory walking distances of 2 miles or 3 miles. And there are transport appeal processes within every local authority. And then the remedy would be judicial review of the transport appeal decision, most likely. Possible that you could go to judicial review before an appeal decision, but you definitely want very, very careful advice before you did that.
I see a lot of them before the Ombudsman as well.
Lots of transport cases go to the Ombudsman as well. But again, I'm not entirely sure that the Ombudsman is the right place to take a transport dispute. Yes, it would be potentially, bearing in mind I'm not giving any advice today, if what you were concerned about was that as a family you had to fork out and you don't think you should have done. But if the transport dispute is stopping the child from getting to school, that's urgent. And that would seem to me to be entirely suitable for judicial review, in principle, subject to case-specific advice.
Just moving outside of SEND specific questions for a moment, many children are eligible for a disabled facilities grant to adapt their homes. How can families challenge decisions made by local authorities about this? Is there an appeals process or a means to challenge? There's not, I think, a DFG specific appeals process. So again, you've got the usual choice between complaint or judicial review. And again, I've been instructed on a number of DFG related judicial review cases, and that may well be the appropriate route. So very much get advice at that point. One of the questions will be, again, what's the implications for the child? Often adaptations are needed urgently in order to meet the child's basic needs. Dignity is being compromised, health might be being compromised. So not appropriate to get stuck in a lengthy complaints process, potentially. So yes, again, very much the diet of SEND's solicitors who have relevant legal aid contracts will include challenges to DFG decision-making.
Parents, as you well know, have really had enough. And as you say, the improvement plan isn't going to change anything immediately. I've heard many talking about a group challenge of, say, 5 or 6 individuals versus their LA, versus their council, rather, using a judicial review about an aspect of unlawful behaviour.
Yeah.
How would they do this? What would it entail? What would you recommend? Those
kinds of challenges can be brought in our system. We don't have the kind of class action culture that we have in the States, but any person who's aggrieved by a decision of a public body can bring a judicial review. And often in the kind of policy type challenges, whether that's to a budget setting decision or a cut or an unlawful policy, for example, on when we do EHC needs assessments, you would want to have a number of claimants. because you'd want to show that a number of people have been affected. What would that number be? Well, it would traditionally it would be something like 3 to 5, because and you would get legal aid normally for 3 to 5 eligible people, and bring the claim on behalf of that number of people. And then others who had concerns would put in witness evidence to expand and to explain their concerns as well, because the court isn't necessarily going to want to be presented with the detailed facts of more than a handful of cases. But those are all standard approaches as opposed to rules. There's no reason why a judicial review couldn't be brought by 100 aggrieved families, all of them as claimants. But you would, I think, struggle to get legal aid. And then the question, if you're not going to fund the case through legal aid, is how are you going to meet not only your own lawyers' costs, because your own lawyers will have an interest in reducing those costs and making it as accessible as possible, but also the local authorities' costs, who, of course, have directly the opposite interest and would rather like you to go away, and so are unlikely to be putting forward, the cheapest barrister they can find, for example. So very practical questions always arise in these kinds of discussions. Who's going to be the claimant and how are we going to fund it is essentially the first thing that any reputable lawyer will want to know. And those conversations can and are often had, with people like me and claimant solicitors. People will explore whether it's possible to bring a claim if we're contacted and ask that question. But it is very important to think practically about how to do this, because the costs of high court litigation are not something to be trifled with, obviously.
We're all aware, I think, that therapy services are really struggling at the moment, broadly, across England. And we've had one parent saying that the health partners in their area are sending generic information sheets, for occupational therapy, speech and language as their educational healthcare plan needs advice, instead of assessing individual children to identify their specific needs. Is this lawful? I mean, obviously it means that the local authority can meet their legal timescales, but it's definitely not child specific.
No. Well, if you think about what the regulations say, the regulation 6 of the SEND regulations says that what local authorities have to get is advice and information about the child's needs, provision that will be required to meet the child's needs and the outcomes that we're looking for the child. And given that all children aren't the same, I am struggling to understand how a generic information sheet could possibly discharge that duty. And although the duty is on the local authority to get that information, that advice and information as part of the EHC needs assessment, the receiver of the request has a duty to respond to it in Regulation 8. So, and of course, we all know that the law is replete with duties on public bodies to work together and to cooperate and to play nicely and to help our children and families. So, yes, I'd be very interested in hearing more about that. And it is a little depressing, isn't it? Because how can a system that operates in that way, and which has that sort of level of lack of regard to the individual needs of children, possibly result in good outcomes for those children?
When your child hits 16, we all know that parents find it a lot more difficult to try to get the support they need. And sometimes they're told, well, your child's 16, so we don't have to listen to you anymore. But what happens if, that happens and your child's views of what they want are actually unrealistic, and it in fact may even be detrimental to the package that they've currently got? What obligation do councils have to listen to parents, and do parents then have to go to get like a legal power of attorney?
Yeah, so there's quite a lot to unpick there, Tania. So back in the old days, in the early 2000s, when I had a lot more hair, I was the secretary to the parliamentary hearings on services for disabled children, and there was incredible evidence given at that time about the black hole of transition to adulthood, which everyone was complaining about. And a major focus of every reform initiative ever since then, and probably the 20 years before then, was on ending the black hole of transition to adulthood. And I think there has been some improvement. I wouldn't accept that it's quite as bad now as it was then generally, but there is still very significant differences in experience for disabled young people, I think, and that 16 to 17-year-old cohort are particularly challenging for services because they're still children, but they do have the right to make their own decisions under the Mental Capacity Act if they have capacity to do so. I'll come on to that in just a moment. The law, of course, in terms of the Children and Families Act, created a 0 to 25 system. So there's no reason why anything should change in terms of education post 16 if you have an EHC plan. Social care entitlements change at 18, move from the Children Act to the Care Act. Health, there is usually a transition at 18 as well. So 16 and 17-year-olds should be treated as children, generally speaking, for the purposes of services. In terms of decision making, the Mental Capacity Act kicks in at 16 for almost all purposes. And so that means that if you are capable of making any decision from the age of 16, you are entitled to make that decision for yourself. But that, of course, premises the question, is the person capable of making the decision for themselves? And there's now tons of law about that question, and much of it relates to young people. Whether the person understands the relevant information, whether they can retain it for long enough to make the decision, whether they can use and weigh the information appropriately to make the decision, and whether they can communicate it, which is almost always the case, because that really just means that they can tell people what they think. Most of our young people are very able to tell people what they think. So often the issue for the group you're talking about, Tania, is going to be whether they can use or weigh up the relevant information to make the decision for themselves, and that's something that people will need, as usual, evidence. If the young person can't make the decision for themselves, then any decision for them has to be made in their best interests by the decision maker. That might be their parent in terms of deciding what they're going to have for breakfast or where they're going to go that day. It will be the local authority or the NHS body in relation to statutory services. But critically, within the framework of best interest decision making, within Section 4 of the Mental Capacity Act, there is a requirement to involve anyone who is involved in the care of the person or interested in their welfare, which will almost always involve their parents and other members of the family, subject to, of course, that itself being in the person's best interest. There'll be a small minority of cases where it's not appropriate to involve family members, but in the general run of things, families must be involved in any best interest decision-making process. And if there's a dispute about what's best for the person, the state, the public body, is expected to take that dispute to the Court of Protection to be resolved by a Court of Protection judge. The parents or other family members would be respondents to that application and would be invited to tell the court what they think is best, and then the judge will make the decision. So in the vast majority of cases, there's no need for any formal decision-making powers for parents. There is a facility for the Court of Protection to appoint deputies, and that's really what we're talking about here, because the point about deputies is that they are people who don't have capacity to decide who they want to make decisions for them. So all of us can make power of attorney for health and welfare or property and affairs decisions, brackets, and we probably should. Those of us who have capacity to give away that decision-making right. For people who don't have capacity in the first place, who, when they turn 16, aren't able to make their own decisions, brackets, you can't make power of attorney till you're 18, but in any event, you would be looking at whether to appoint a deputy. And as the name suggests, the court-appointed deputy deputizes for the Court of Protection and makes the kinds of decisions that a Court of Protection judge would normally make themselves. It's quite straightforward to get property and affairs deputyship. If the young person has any significant sum of money of their own to manage, more than just welfare benefits, then you can make an application to the Court of Protection and be appointed as the property and affairs deputy. And that happens routinely. People don't necessarily need legal advice to make those applications. If you want to be appointed as deputy for health and welfare, you've got to take account of a very important decision of the Court of Protection in a case that's referred to as remotram. There was a group of families who brought a case together to try and get clarity about when will the Court of Protection appoint welfare deputies. I'm not sure, unfortunately, the judgment gives that much clarity, but what it essentially says is there's got to be a good reason as to why you should be given the power to make decisions for your young person, as opposed to either making best interest decisions collectively or applying to the court on a case-specific basis to make a particularly important decision, like where is the young person going to live. So a case that might well result in health and welfare deputyship being granted would be where a young person needs a lot of medical interventions. And each of those medical interventions has benefits and risks. And everyone, including the doctors, thinks that, for example, the mother is best placed to balance those and make the decision as to whether to go ahead or not. In that situation, I can well imagine the court saying, well, it's not appropriate, it's not in the best interests of P for this issue to have to keep going back to court because it's going to be expensive, it's going to be time consuming and so on. So we're going to give deputyship to the mother and she can then make those decisions on the young person's behalf. If there was any suggestion that anyone disagreed, then almost certainly the court wouldn't grant deputyship and would say, well, if there's a dispute, we'll resolve it. And sadly, parents often think, well, I need to be appointed as deputy because I don't agree with the local authority about where my son should live. That's precisely when you won't get appointed as deputy, because there's a dispute that needs to be resolved, and that would have to be resolved by the court. So as usual, I'm going to be saying that parents need advice about this. Don't just send in an application for health and welfare deputyship saying, I've always made decisions for Johnny and I know what's best for him and I should continue to be allowed to make decisions for him, because that will almost certainly involve wasting your application fee, and you'll be sent a very nice standard order saying, we know that you care about Johnny very, very much, but that's not how it works post 16. So make sure you get advice.
Still looking at the older end of children, is there any legal recourse if there's a recognised need for continuing education beyond 18 in an educational healthcare plan, but the local authority actually has no suitable provision available? I mean, could a parent then perhaps source something that would be educational, but perhaps isn't run by a college instead? Absolutely.
So, of course, we know that the requirement to maintain EHC plans runs up to, and indeed potentially beyond 25, and nothing changes really. So very much like as if it was a younger child, if there's no mainstream or maintained provision, then the EHC plan should specify and name something else which is going to meet need, and the tribunal will require that in the event that there's nothing from the statutory sector which is available. So really the fact that we're talking about a 19-year-old here as opposed to a 9-year-old in the EHC plan context makes no difference. It makes a difference in other areas. For example, there's no Section 19 duty, there's no obligation to ensure that at all times suitable education is being provided. But within the context of the Children and Families Act, the entitlements are the same.
You've got your EHCP hard one, and then the LA removes provision that was in Section F. What can you do?
Appeal to the tribunal.
Even if it's mid-year or...
Well, the only time that an EHC plan can be amended is following an annual review. But of course, an annual review doesn't have to happen annually. It can happen at any time. So the local authority would review the plan, decide to make changes to it, and issue a new plan with a decision notice that says, if you don't agree with these changes, you have the right of appeal to the tribunal. And parents would then need to appeal to the tribunal. And this is something, of course, that parents are understandably rather dismayed to discover, which is that what you win at tribunal is really only an EHC plan for a year, or not even potentially, because things can be changed and can be taken out, perhaps properly because needs have changed and there's new information. But if there's no good reason why provision should be removed, and the evidence is that the needs remain the same, it's going to be very difficult for the local authority to resist the tribunal appeal, and parents might want to be pointing out that they've acted completely unreasonably and be saying that you ought to pay our costs in the tribunal because this is completely unreasonable. Why are we here? We know that the threshold for getting costs in the tribunal is very high, but there are examples where public bodies act so unreasonably as to potentially trigger the tribunal's power to award costs. So that's something parents can think about. But yes, I'm afraid the local authority can change the plan. And if you don't agree with those changes, you'll need to appeal and get the tribunal to put everything back in.
So a final question here. If your LA social care team during the EHC needs assessment says not known to service, we're not going to do an assessment. It happens all the time, doesn't it?
Yeah.
What can you do?
So this issue about social care involvement in EHC needs assessments, I think really gets to the heart of what is suboptimal, shall we say, about the Children and Families Act, because it's far too complicated. And there should just be a straightforward requirement that if you're not currently known to social care, and if you would like some social care input, they must assess. My view is that is the law, because we know that under Section 17 of the Children Act, generally, there's no particular test for when a local authority has to carry out a social care assessment. If a child is or may be a child in need, and all disabled children are children in need, then a local authority has to assess their needs. Certainly if anyone specifically asks them to do so. And so when the request for advice and information comes from education to social care, that, in my view, is enough for social care to then have an obligation to say to the family, would you like some social care? Shall we assess you? And the family might say, no, thank you. We've got absolutely no interest in having any short breaks or any other form of social care support, in which case, fair enough. Then the answer that says we don't know this family and they don't want any service from us would seem to me to be a reasonable one, because we know that all services for children in need are voluntary. But if the family think, oh, well, actually, yes, a bit of short breaks might be rather handy, then the local authority would have to carry out an assessment, because that's the law. Generally, you don't need the Children and Families Act to say anything about that. I would like that to be a more straightforward answer. It would be great if the statute or the regulation said this, but I think that the general law on social care abundantly clarifies what the position is. And it may be that we need a judicial review at some point to get some case law that nails that on. The problem, I think, is that in any case where a judicial review is threatened, they do an assessment.
Yeah.
And so the question will always be, in these sorts of areas of dispute, is how would you ever get a judgment that nails something on? So I'm just going to keep saying that, in my view, it's obvious that it's required until a local authority seeks to persuade a High Court judge otherwise.
Well, that's all we've got time for today. We just hope that this has helped you some way understanding what is going on now with the law. Things haven't changed, and to have answered some of your questions. Thank you, Steve, as ever, for your generous time and for helping parents out as you do every single day.
It's a pleasure. Thank you very much for having me, and looking forward to the roundtable.
Thanks. And please do like and subscribe to our podcast, whatever platform you're watching or listening on, as we have more to come. But for now, thanks for listening.
So goodbye from me, Renata, and Steve.